In a Colorado divorce, when assets are being divided, one of the more challenging assets to divide is often real estate. Particularly when, as in most divorces, the real estate is really just the marital residence. So it's one piece of real estate that stands apart from the rest of the marital estate being all the other property that's been built up during the marriage. And the reason it's challenging is very often that real estate, that marital residence, represents a large percentage, probably the biggest percentage of all the assets in the marriage. It's not easily divisible, right? You can't cut a house down the middle. You take the left half, the other spouse takes the right half. It needs to be divided because as the single largest asset, it will be difficult to offset that asset with even all the other assets in the marriage. And that presents a big challenge. So unless one party is willing and able to buy the other party out, very often the only real way to get this done is to have that property liquidated, to have the property sold and the proceeds of the sale divided between the parties. This is where coming to an agreement can be very, very powerful, because you can be a lot more creative in an agreement. Like certain things that I've seen done, for instance, are they agree that one spouse can keep the marital residence until the children reach majority, and then they'll sell and divide it. Or the parties will somehow split living in the marital residence, or some other mechanism to allow the parties to keep the marital residence for a period of time or for all time that does not involve a straight up buyout. But those are the kind of things that can only be done during agreement. If there cannot be an agreement, or there is not an agreement, and the court is asked to decide, the court will very often order the liquidation of the residence so that the parties can divide that property in an equitable way. Another asset class that can pose major challenges in dividing a marital estate are retirement assets. And really, we have to think about retirement assets as two different classes. We have fixed benefit retirement assets, like a pension, where you worked at a job for 20 years, or one spouse worked at a job for 20 years, and then based on that, this pension is going to pay out for the rest of that person's life. That is very different than the defined contribution type plan, like a 401k or an IRA, where one spouse put in a set amount of money over time, and based on how much money builds up and the interest that accumulates and all the other good stuff in that account, that money will provide a certain annual or monthly benefit when the person retires. The latter, the one I just described, the fixed contribution plan, is by its nature actually easier to value. You can say what that account looked like at the date of marriage, how much money went into it, and how that money grew during the marriage, and it can be divided. The fixed benefit plan is much more difficult because you have to have an expert determine what that future benefit was worth at the time of marriage, what that future benefit is worth today, and therefore put a value on that retirement account. As to both, then that doesn't unlock the value for the parties right now. If you wish to access the value of that, there are penalties to be paid unless the retirement account is transferred in a qualified way to the other person as a retirement account. And that is done through something called a Qualified Domestic Relations Order, also known as a quadro, which is a special order of the court made and created under IRS law and under state revenue law that allows a transfer of a retirement account to another party without incurring the penalties. That doesn't mean that you can then access the funds. The funds are as restricted as they were at the time that they were in the retirement account that was original and before they were moved. In making decisions around transferring retirement accounts and whether or not that's the right thing to do in your divorce, you should certainly consult with your divorce lawyer or with us if we are. But also, it's often wise to also involve a tax attorney or a CPA to help advise you on the tax implications of moving the retirement accounts. We've been talking a lot about the division of assets in a Colorado divorce, and one of the other questions we have to deal with is, how are debts divided? And the answer is actually in very much the same way. It can be very helpful actually just think about debts as negative assets. We'll look to the same things as to whether they're separate debts or marital debts. Then they go in the marital estate. and they get divided equitably. And this is another one where the equitable word can become very, very important because it doesn't mean equally, it means fairly. And sometimes we look at debts and ask the question about whether or not the other spouse knew about them, whether that debt was acquired in a fraudulent or duplicitous way, or whether this was simply a debt of the marriage. If the debt became some sort of waste in the marriage, that the equities might favor allocating that debt to the party incurring the debt, or at least more proportionately to that person, depending on how that debt was incurred. But generally speaking, debts are divided in much the same way in an equitable fashion between the parties based on their use during the marriage. How are vehicles and personal property divided in a Colorado divorce? They are divided in much the same way as all other assets. We will usually list the vehicles and other personal property, a couch or piano, coin collection, and even personal property that is less easily valued, a pewter collection, the dinner service for 12, figurines, whatever. There's been so many different things that we've had to work on with folks, and that's where we really get into some challenges. So cars and other personal property, to a large extent, can all be valued fairly easily. I mean, there's sources and or experts who can say what a car is worth, who can say what a set of china is worth, quite honestly. But when it comes down to what about, in fact, I'll just relate, the George Foreman grill. That was a case that I had a long time ago. And, we could all agree that a George Foreman grill is worth $300 or whatever the amount was at the time. But this George Foreman grill was a gift from one party's grandma to the marriage, and they valued it very sentimentally. And how you list those things, unique photographs, original photographs of ancestors or of even of children, and other special things that cannot be easily valued must also be allocated and divided. And that's where the word equitable comes into play again. But it becomes very subjective. What is equity in such a circumstance? And let me just tell you this. The answer to that question is it's what you guys can agree to. You can agree on some things and not other things. But if you don't come together and agree what's equitable and as fair as possible to you and the other party, then you're going to throw it over to a judge to decide. And a judge is going to literally, or I guess figuratively, use the wisdom of Solomon, and you're probably not going to like the results. Question is, can gifts or inheritances be considered marital property in Colorado? The answer is yeah, can be. Can also not be, and it really depends, and it is really important in prenups and premarital agreements and marital agreements, and sometimes when major gifts are made. Important to consult with an attorney when the gift is made to make sure that it's made in, shall we call it, the right way. Because some gifts might be considered gifts to the marriage as opposed to gifts to one party or the other. Inheritances might be considered inheritances of the marriage. So you want to be sure that if you want them to come in as separate property, that the language of the gift or the language of the inheritance is clear as to that fact, so that there's no dispute as to whether it was in fact marital property or separate property. Generally speaking, an inheritance will be separate property. Generally speaking, a gift will be the property of the person to whom it was gifted. But it really pays to make that clear so this doesn't become an object of debate or dispute during the course of a divorce.